Today, we are talking about contracts and business law. We enter into contracts every day and may not even realize it. Each time we order that Starbucks coffee or fill up our car with gas, we have impliedly agreed to pay for our products. When we agree and click on page after page of Instagram or Facebook's terms, we have agreed to abide by its terms, which often include the right to use your content without paying you. The U.S. Constitution states that no state shall pass any law impairing the obligation of contracts. This is in Article 1, Section 10. A contract is legally defined as an agreement between two or more parties that is enforceable by law. Contracts can be oral or written. Oral contracts are permitted and enforced unless they are required to be in writing. Per the statute of frauds, certain contracts must be in writing to be enforceable. These include the transfer, sale, purchase of real estate, a property lease over 1 year, a contract in consideration of marriage, though the refusal to marry is a defense, a contract to pay a debt of another, for example, let him attend Phoenix College, and if he does not pay, I will, and a contract which cannot be performed within 1 year. Contracts can be express or implied. With an express contract, the parties explicitly state the terms of their agreement, for example, a catering contract. With an implied contract, the conduct of the parties evidences a contract. For example, ordering food at a restaurant or filling up your car at a gas station. Contracts can be bilateral or unilateral. With a bilateral contract, parties exchange promises. Promise for a promise. I promise to pay you Tuesday for a hamburger today. With a unilateral contract, one party responds to another party's offer by performing some act. The acceptance is by performance. It's a promise and an act. I offer a $50 reward for a person who finds my dog. The act of finding the dog represents acceptance of the offer. A contract can be executory or executed. An executory contract is a contract that has not been fully performed. For example, a real estate lease is not fully performed as the tenant must pay rent each month, while the landlord must provide the space. An executed contract occurs where performance under the contract has been completed. Sometimes contracts are void or voidable. A void contract is a contract in which the law does not recognize and will not enforce. For example, a contract to kill another. A voidable contract is a contract in which the law recognizes, but it may be legitimately canceled. For example, a minor buys a car. The minor can void this contract. Also, the minor can affirm the contract when he turns 18. The requirements for a contract to be enforceable include the parties must be legally competent, there must be a valid offer and acceptance, legal consideration must be exchanged. Sometimes the contract must be written and signed under the statute of frauds. In the case of a breach, the defendant's breach must have caused plaintiff's loss. The first requirement, legal competency, requires the following. The parties must be 18 or older. The contract is voidable at the option of the minor. The minor may disaffirm. If the minor does not disaffirm, he can affirm when he reaches 18. The parties must be of sound mind. There must be no physical or mental defects. There must be no impairment of drugs or alcohol. You may know of certain Hollywood stars who quickly married in Vegas, only to get an annulment a few days later, claiming they were too drunk to understand what they were doing at the time. A valid offer and acceptance is required for an enforceable contract. The party who makes the offer must show intent to be legally bound. The offeree must accept the offer on the terms proposed. A counteroffer is a rejection of the original offer. For example, Art offers to buy Betty's artwork for $100. Betty says that she accepts the offer to sell it for $200. This acceptance is a rejection of the original offer. The terms must be definite. For example, I'll pay you $50 per week for your promise to mow my lawn. The offer and acceptance show intent to be bound, acceptance of the terms, and the terms are definite. But if the offeree says he wants $75, that's a counteroffer, and there is no contract, unless the offeree accepts the new terms. How do we treat jokes? You tell your friend, I'll give you $1 million if you give me a massage. We use the reasonable person test. Advertisements are usually construed as invitations and not offers. Let's say Sally sees an ad for dresses for sale, and she drives to the shop and declares, I accept your offer to sell one of your dresses. The owner then tells her she changed her mind. The dresses are no longer for sale. Did the owner breach the contract? No. The law views the ad as merely an invitation and not an offer. An exception occurs if the terms are specific. Had the owner said, the first 10 people to arrive at my shop may buy a dress for $5. This offer shows an intent to be bound. The acceptance must be by the means specified in the offer unless there is no specification. In that case, reasonable manner is okay. If no time is stated for an acceptance, the offer is open for a reasonable period of time. If the offer is revoked prior to acceptance, there is no contract. Consideration, the third requirement for an enforceable contract, means that each side gets something, each side gives something up. Consideration might be money, for example, for a cup of coffee, a legal right, for example, giving up the right to build on your property in exchange for use of a neighbor's well, services, for example, shoveling snow in exchange for money. Usually, courts will not inquire as to the sufficiency of the consideration. No consideration occurs when there is past consideration. For example, I already gave you a TV on Monday, and now you offer me money on Tuesday. No consideration also occurs where there is a pre-existing duty. For example, a police officer has a pre-existing duty to respond to emergencies. So there's no consideration where a woman offers to pay an officer $100 to find her kid. Again, courts usually don't look to the adequacy of consideration. For example, I agree to pay you $1,000 for a car I could have bought elsewhere for $200. Accord and satisfaction take place when there is a genuine and good faith dispute. An example might be a dispute over the amount of debt owed. If the parties agree to a lesser amount owed, the debt is extinguished. Promissory estoppel is a special type of equitable remedy which a court might implement in certain cases to be fair. This might occur when there is no consideration, but it is foreseeable that one party relies on another party's promise and that party incurs expenses. The court looks for foreseeable reliance plus expenses incurs. An example might be employee Eric retires in reliance upon his employer's promise to pay him a pension. The employer later reduces the amount of the pension. Although consideration is lacking, if a court implements promissory estoppel, the full pension must be paid. Another example might be Art agrees to buy John's boat if John repairs the engine. John relies on Art's promise and makes the repairs, and then Art changes his mind. Even though consideration is lacking, a possible remedy is that Art has to buy the boat or reimburse John for the repairs. Remedies for breach of contract include a lawsuit for damages. Here, the plaintiff seeks money. Specific performance. For example, you purchase a unique piece of art, or Taylor Swift bails on her agreement to perform. Rescission of contract, for example, in cases of fraud. Loss or damages can be several types. Compensatory damages refers to damages that are reasonably foreseeable. For example, the seller breaches a contract to sell goods for $50. The buyer pays more for goods from someone else, and the cost is $100. The damages equals the difference in the amount paid, or $50. Damages can be nominal damages, which are token damages. Damages are nominal if the plaintiff can't prove actual damages. Assume the same example we just discussed, where seller breaches a contract to sell goods for $50, except this time buyer buys goods from another seller for $50, the exact amount she was going to pay the original seller. Here, the damages are nominal. Liquidated damages are damages which are written into the contract. Punitive damages are like a fine and are very rare. You may be familiar with the Stella Liebig versus McDonald's case. This is known as the hot coffee case from 1994. In this case, an elderly woman spilled coffee after placing the cup between her legs and trying to pull off the plastic cover while driving. She suffered third-degree burns. Stella Liebig claimed her injuries were the fault of McDonald's because they served coffee hotter than other places. A jury awarded Stella Liebig $2.9 million, $2.7 million, which were punitive damages. Contracts are void when their subject matter is illegal, when they contain an illegal act. These types of contracts are void: an agreement to injure or kill someone, an agreement to damage property, an agreement to commit fraud, charging a usurious interest rate, gambling, or prostitution. Contracts against public policy are also void. Non-compete agreements are void unless the time period and location are reasonable. For example, a physician who leaves a practice and whose non-compete states that she may not practice in the same state for 25 years is unreasonable and thus void. Contracts are voidable by either party in the case of mutual mistake. Mutual mistake means the contract achieves what neither party intended. For example, a contractor who digs a hole in someone's backyard only to discover that just below ground level exists solid rock. The contract to build in that case is voidable. Mutual mistake must be distinguished from unilateral mistake. In the case of unilateral mistake, the contract is enforced. In the case of fraud or material misrepresentation of fact, the contract is voidable by the innocent party. For example, you are told by salesman Sam that the Tacoma has only 9,000 miles and one prior owner, when in reality it has 30,000 miles and 3 prior owners. Sam lied and set the odometer back. You can void the contract. Usually, parole or oral evidence cannot be introduced into a court to contradict the terms of a written agreement that is complete. This is known as the parole evidence rule. An exception occurs in order to clarify any ambiguity in the written instrument. So the more complete the agreement appears to be on its face, the more likely the court will hold it is complete. The more likely the court will say that no oral or parole evidence is allowed to come in. For example, I agree to buy your class notes for $50, and we put this agreement into writing. After class, you hand me 1 page of notes. I claim that I am not bound by our agreement because you agreed to write more than 1 page of notes. Does the parole evidence rule let our oral agreement in? No. The written agreement is complete on its own. Business associations include sole proprietorships, partnerships, limited partnerships, corporations, limited liability companies. A sole proprietorship is a single individual who owns her business. The owner has the responsibility and control over the business. She enjoys the profits and suffers any losses. An example includes retail stores, services, professionals. The individual has no legal identity apart from the owner. She has personal, unlimited liability. She is taxed as an individual. Partnerships are an association of two or more people. Each partner is personally liable for partnership debts. For example, a creditor who obtains a judgment against the partnership may enforce that judgment against either or any partner. Each partner acts as an agent for the other partner. Withdrawal or death of a partner terminates the partnership. Limited partnerships include a general partner who is responsible for the day-to-day operations and has personal or unlimited liability. There is also a limited partner who only provides capital for the business. He does not participate in the day-to-day operations, and his liability is limited to the investment amount. Corporations have limited liability, perpetual existence until dissolved by law, transferability of ownership. Some disadvantages are double taxation. The earnings are subject to taxes. The earnings distributed to shareholders are again subject to tax. There are regulatory formalities, the filings of annual reports with state agencies, articles of incorporation, and shareholder meetings. Limited liability companies, or LLCs. LLCs are limited liability, like a corporation. They are personally taxed, like a partnership or a sole proprietorship. This concludes the podcast for Contracts and Business Law.